So my update should be pretty quick. I'm happy to, if there's any questions or comments arising out of it, let me know. But the things that I wanted to talk about was just, there's a new guideline that's been put out by the Office of the Information and Privacy Commissioner, specifically for landlords. Is anyone aware of that, just by show of hands? Have you heard about it, seen it? Some of you. Okay, so it's probably useful to talk a little bit about then. And then there's a case that, I mean, kind of covers a little bit of an information and privacy issue and some other issues. SA versus Metro Vancouver Housing Corporation. This was a tenancy case that arose in BC that I began as an advocate and worked with another lawyer up until the BC Court of Appeal level, and then it went on to the Supreme Court of Canada. And there were some pretty important principles that arose out of that, and that talked about issues that I think are something that we see in our work quite a bit. And then I've got also a housing co-op case. I'm not sure, how many, do you see co-op housing cases just by show of hands? So few of you. And I know that it can sometimes be tricky to navigate those issues. How many are you actually assisting on co-op housing? Just a couple of you? Yeah, wow. But it sounds like more of you are seeing it in your work, and then, so it does come up a little bit. Okay. Okay, so this Office of the Information and Privacy Report, it's available on the OIPC's website. That's the link to it there, and it's called Always, Sometimes, or Never, Personal Information and Tenancy Screening. It came out last year, and I think I just stumbled on it, which is why I thought that maybe we should talk about it as an update. Because I do think it is helpful if you're supporting tenants in finding housing, or if tenants are coming to you and they're saying, look, the landlord's asking me for X, Y, and Z, are they allowed to do that? And basically the OIPC at the beginning of its report, and it was authored by Drew MacArthur, who is the acting Information and Privacy Commissioner at the time. This report came as a result of that office receiving calls, quite a few calls from individuals who'd been asked by potential landlords for all kinds of information, including medical information, bank statements, T4 slips. And I think it's helpful that the Commissioner acknowledged the fact that lower vacancy rates in Victoria and Vancouver especially, but I know that I've heard that there's also some increasing pressure on some of the smaller communities as well, so I acknowledge that. And in any event, that there's a significant power imbalance between landlords and tenants, just given the nature of that relationship. And so that's something, you know, that office was alive to, and thinking about how information and privacy should work between landlords and tenants. So I kind of like how this report talks about things that are always something that can be disclosed to a landlord, some things that are kind of in that gray area, or maybe sometimes, and then things that would never be, that a landlord should never be asking for. So hopefully that's helpful to you in guiding your own work. Just in terms of examples of things that landlords are always authorized to collect. So information that clearly relates to and is reasonable for the purpose of assessing the tenant. So references and contact information would be examples of information that's always appropriate. Interesting, I actually didn't know this till I read this report. Consent's not required to collect personal information that's publicly available. However, landlords are supposed to notify tenants that they've relied on that information. So information that can sometimes be collected, it might be a tenant's age, again, depending, is that relevant? Is it for the purpose of something that's relevant to that potential tenancy? Proof of income or employment, that's again gonna depend on the circumstances, and credit history. So again, the OIPC is saying it really depends on the context and whether that information could be collected in a different way without violating so much of someone's privacy. So the examples that are given in the report are if the tenancy housing for people who are 55 plus, then obviously age is going to be relevant. It's not going to be relevant in a different circumstance. Credit checks are something that a landlord can rely on, but only if they're unable to get satisfactory references or employment or income verification elsewhere. And then information that can almost never be collected, whether the tenant is a smoker, which is kind of interesting after talking about policy guidelines about smoking, and information collected from internet searches and social media platforms. I guess that would be like trying to get someone's information from Facebook. Is there a question?
Yeah, I have a question regarding, can you hear me? Criminal record checks. It's my understanding that within the last year, the rules on that have changed as well, where it's now actually allowed under the Human Rights and Privacy Act.
I'm pretty sure that this report says you shouldn't be getting criminal record checks.
The wording changed this year when it was released, and the wording was changed to that it was acceptable to ask for a criminal record check. From
this report, which has kind of a chart that talks about always authorized, sometimes authorized. So it's saying always authorized is consent for a criminal record check. Also, this report arises because there's systemic issues around the type of information that's being collected and how it's used. I'm hoping that by just kind of flagging this report that it can be utilized by advocates in cases you're seeing to kind of point to and say, well, you know, you've got one government body over here saying that this isn't appropriate in certain circumstances. And if it doesn't meet the circumstances that the OIPC sets out of when it's reasonable. Yeah, and I guess, I don't know whether you can really force the RTB to adhere to the guidance that another government office provides, but it should at the very least be persuasive. And I think the fact that this report was developed specifically recognizing that there is a systemic problem around information and privacy and tenancy. And again, I like that this commissioner has highlighted the fact that there is a power imbalance, that there is a housing crisis that we're in, and that those things are relevant to the vulnerability of tenants and prospective tenants that should be considered, and hopefully is going to be considered by the RTB more so going forward.
Information about employment. I think it's a human rights code violation to discriminate tenancy based on lawful income. Isn't that, it just strikes me as a way to get around that and still discriminate based on lawful income, that being income assistance.
Yeah, that's a good question, because when I go back to that, I was kind of curious about in what context. Again, it has to be relevant, and there wasn't an example there of how it would be relevant or appropriate to ask. And then on the next couple paragraphs in the report says you can't ask stuff that's protected under the Human Rights Code. So yeah, and your source of income is a protected ground under the Human Rights Code. So whether your income is derived from income assistance or disability assistance is not a basis on which a landlord can deny you tenancy. So yeah, it's a good question.
In respect to Human Rights Code, and look, this happened years ago. I had one of my clients come in and say, my boyfriend wants to move in with me, but the landlord wants him to do a background check because she says he looks creepy. And I said, well, that doesn't sound right. That sounds like a form of discrimination because he has a glass eye, I think it was.
Mm-hmm.
And
yeah, absolutely. I would say that's discrimination, and I think you're flagging something important to, again, around that line between what's reasonable and relevant, and then also what's you're just discriminating against someone now. You can't be asking questions or taking steps that are going to violate the Human Rights Code, and that's potentially discrimination. It could be discrimination based on disability, could be any number of things. So I think it makes sense to be challenging landlords when you can about the information that they're collecting and why they're collecting it. At the same time, I know that there's a real reality as well about, people trying to stay housed and or trying to get housing, secure housing at all, and then what's the best way of going about that in terms of the strategies you use? So yeah, well, and I think, this is a pretty big report. I'm not sure, it's quite a few pages, so it's probably good to really dig in. I'm providing a very surface, kind of just letting you know it exists and giving some very basic highlights, but I would have a look into it to see if there's anything there that you can utilize to, one, it can't be a human rights violation, and this report itself is saying, you can't ask people questions that relate to a protected ground under the Human Rights Code. So if you think, if it doesn't really pass the smell test, there's something there that doesn't feel right, I would definitely give some consideration to that. But I'd also look at the report in a deeper way to see if there's something in there that's useful to you.
The Residence and Tenancy Act has to abide by PIPA or FIPA. That's what reigns supreme is the privacy law. So if there is if you have RTB decision and you do have something, then you should be able to make a privacy complaint. The privacy commissioner consent can make orders, and that would include against the RTBs. So you should be able to not win your case, but at least send a message to the RTB that they may have the interpretation wrong.
Yeah, it's a good suggestion. Your client definitely has a right to bring a complaint against a public body if, there's an information and privacy concern that's going on. They have the right to bring that to the OIPC if that's something that they want to do. That's something that. Well, you have 1 year to bring an OIPC complaint. So, if a client's interested, it might be something worth pursuing. It's definitely an option to consider. Did either of you have anything to add to any of this discussion? No?
No, it's still unsure about what a lot of this means and how
I know.
it plays out.
I feel like all of us have to take a closer look at it as situations arise,
Yeah.
and hopefully utilize it for the better, not as much as we can. So the other thing that I just wanted to flag for this report is this report also talks about nonprofit housing providers, because sometimes we have concerns about nonprofit housing providers as well. And I say that working at an organization that is a nonprofit that provides housing. So the report talks about how you can't apply everything to landlords generally to the nonprofit housing sector, because sometimes for the purpose of, for example, subsidized rent, there's going to be a little bit of a different analysis going on there in terms of what information is appropriate to collect for tenants. But I think it's important, and I underline this, and this is something that the report speaks to in a few different places. Organizations are still limited to collecting only personal information that is reasonable in the circumstances. So if you think that a nonprofit housing provider in, for example, their rent calculation guide, in income verification is just asking for more information that is reasonably necessary to establish that that person has a right to subsidized housing, then don't be afraid to query that further to, with your client's instructions to challenge those things. Which leads me to SA and Metro Vancouver Housing Corporation, because this is a case that was exactly that. This was a case where the client had a discretionary trust established. She was a person with disabilities who had provincial disability benefits, and she was filling out her regular form that you have to fill out for subsidized housing to determine her eligibility. And the landlord wanted to know how much was in this discretionary trust. And as many of you will know, if you also are dealing with income assistance, discretionary trusts are treated as an exempt asset by the ministry. And in my work, up until I ran into Metro Vancouver Housing, or MVHC, most landlords were treating discretionary trusts as sort of this exempt asset or something that they weren't concerning themselves with. For those of you familiar with BC Housing has a rental assistance guide for nonprofit housing providers, for example, that also sets out there's these exceptions, and we're as government entities, we're not treating discretionary trusts as assets. Well, MVHC decided that it was its own body, and it could do what it wanted, and it could create its own policies, and it could decide that a discretionary trust was an asset. And originally, the Office of the Information and Privacy Commissioner agreed with the landlord, and the lower courts agreed with the landlord, and the matter ended up at the Supreme Court of Canada, where thankfully the Supreme Court of Canada finally said no one else treats a discretionary trust as an asset. It's in terms of how a discretionary trust actually works, it's not even truly an asset, because someone doesn't have a right to just demand that money, so you can't treat it that way. So the fact that she didn't have an actual entitlement meant that the housing provider could not treat it as an asset, and they couldn't ask for more information about something that wasn't her asset, and her not providing that information did not mean she was disqualified from being considered for a rent subsidy. So they had to consider her for a rent subsidy and not have that information. So it's just sort of an example of why you might want to challenge landlords requesting information. I mean, this case is kind of extreme in the extent that it went, and hopefully having this precedent is helpful in seeing other landlords maybe not picking this fight, but we'll see. And then the last case I wanted to talk about was Potter and Vancouver East Cooperative Housing Association. Again, I know most of you your day-to-day isn't co-op housing, but I think this is an issue that probably does come up when you are dealing with co-op housing, which is when someone's underhoused or overhoused. And in this case, co-op members brought an action against the co-op, and there's a section under the Cooperative Association Act which allows members to bring an action against co-op for oppressive or unfair actions. And in this case, the members were saying, look, you're allowing long-term co-op members to stay overhoused. So maybe they had kids that had grown up and they're no longer in the house, and they were allowed to keep for say a 2-bedroom unit when they're one person, and they weren't very quick to make those folks move on. At the same time, you had people who were underhoused, so people who didn't have enough bedrooms, who were just waiting and kind of languishing on the wait list. And the court ended up deciding that this practice was not okay, that it was unfair and prejudicial to other members in the co-op to allow those long-term members to be overhoused when there were others that were underhoused. And one of the things that the court looked at was the mandate of the co-op, which was to provide sustainable and affordable housing to its members. So they were saying basically you couldn't have this policy, whether formal or informal, to allow members to be overhoused when other members were underhoused, because that does not provide sustainable and affordable housing to all your members in doing that. Yeah, so that was my that was all I had to say about that case, unless there were, questions or comments about.
Do you see tenants in other other nonprofits being able to use this case law, even though they're not living in a co-op, but in a nonprofit?
I mean, unless you're in a co-op, you can't rely on this. But one thing that's, I mean, there's the new, the Societies Act has been updated recently to include some new provisions that kind of mirror some of this language, but that would be for members as opposed to non-members. So
you're saying it's kind of restricted, in terms of like practical use, it's restricted to other co-ops?
This case, yes.
Thank you.
Yeah, but as tenants would, I mean, they're tenants, so they would have their tenant rights under the Residential Tenancy Act and the policy guidelines. And I know, to the extent that those are, that those are accessible and useful.
It's a common complaint, and by tenants who are desperately in need of housing and need to move into like their family member, have a growing family, and then watch as other people in the same building. And so that's why I was wondering if it was applicable in any way. That's a good point, because you're right that is something that comes up it's a common complaint, and I say, well, good luck, right? But what I mean is, we can advocate, but can we compel?
Yeah, I mean, there may be, I'm just trying to think kind of creatively about what you could do about that. I mean, I think one thing, there may potentially be a human rights complaint in that. I mean, it would have to be facts that would lend itself to, have to show discrimination based on some kind of ground, maybe family status could be. I'm not sure do either of you have thoughts about that particular problem of nonprofits, kind of like if this scenario were happening in a nonprofit as opposed to a co-op? Yeah. Oh, good.
Okay, I think you can try it. I think if the nonprofit has a similar mandate, then you can at least say that this is persuasive, in short. I should add that in this case, the co-op also, it was failing to take the overhoused members and put them into smaller units. So I don't think this case says that you should be able to kick those people out if there's no other unit. There has to be a unit for them to move into that's appropriately sized.
They just were like really slow.
Yeah, they were slow, and I think where the members who were overhoused were saying no to the smaller units, they were just letting them stay in the bigger ones, which that's silly.
Yeah.
Thank you.
And you had something?
I was just going to say, I agree with Susanna. I think if there's a nonprofit housing provider that has a similar mandate, you could certainly bring this case up, and it may be persuasive to a court. So, could be useful.
Well, and you two saying that makes me think it could also be useful to maybe raise that with the board, for example, of that nonprofit, to say, look, it's the same kind of principles. Like if this is, you could rely on that organization's mandate, possibly, to say, look, if your mandate is to provide housing, like you shouldn't be doing this in this unfair way. And I also think that there's stuff in the RTA that you could potentially rely on. I'm just trying to think that through, but maybe you can make a creative, quiet enjoyment. I probably have to think about it more, but I think there might be something there. If you have a nonprofit housing provider, theoretically they should be compliant also with, BC Housing or like government policies or guidelines around overhousing and underhousing. You could cite that to say you're not acting in compliance with, what are considered general standards of how you do this, right?
I mean, if you were to try to make these same arguments to a nonprofit, you wouldn't go to the RTP, or would you?
Well, I think this would be a letter probably potentially to the board of directors. In the hopes that this could be persuasive to the board and saying like, look, you're not even really meeting your own mandate here. And hopefully you would also have some kind of an RTB claim that you could bring as well. And also you could consider whether there was a human rights aspect to it. Yeah. Okay, well, if there's no other questions or comments on that, I'm going to turn it over to Danielle.